Welcome back to Vox Terra. Today we're going to look at West Virginia versus the EPA, a recent Supreme Court case that, based on my reading of environmental organizations, amounts to serving the interests of the fossil fuel industry and hobbles the EPA's ability to make new rules. This decision was made by a 6-3 majority of the so-called conservative judges. Now, you know why I say so-called, because everybody has an identity, whether it's conservative or liberal, for a different set of reasons. So what I believe has happened in the, let's call it, climate denial industry is that industry has wrapped themselves in a conservative cloak, thus getting buy-in from people who wouldn't otherwise normally agree with them. Well, citing to the Natural Resources Defense Council, the Clean Air Act of 1970 charged the EPA with fighting pollution at the federal level, explicitly authorizing the EPA to define, quote, best system of emissions reduction, close quote, for each industry. Very broad language appearing to give the Environmental Protection Agency a lot of discretion in how to limit pollution, without needing to run back to Congress and the courts to get permission each time they come up with a new rule. And citing to Inside Climate News, in 2007, the Supreme Court affirmed in Massachusetts versus EPA that the EPA does indeed have the authority to regulate greenhouse gases, or those heat-trapping gases. So now getting to this present case, in 2015, the Obama administration enacted the Clean Power Plan, and under that plan, the EPA determined that power companies could cut their emissions through a combination of installing emission controls and transitioning towards cleaner or lower carbon energy. Well, citing the NRDC, coal companies, aspects or elements within the power industry, as well as aligned states, sued to block that Clean Power Plan. And the Supreme Court issued what was called a stay, meaning you gotta pause that plan. But that's after Obama was already out of office anyway. Well, Trump also came in saying he's going to repeal the Clean Power Plan and replace it with what the NRDC, Natural Resource Defense Council, called a do-nothing alternative, called the Affordable Clean Energy Rule. So now I'll get even closer to this present moment. In 2021, the U.S. Court of Appeals for the District of Columbia struck down Trump's repeal of the Clean Power Plan. And President Biden's EPA head, Michael Regan, said they would write a new rule with a clean slate. So in a lot of the articles, and I've looked at what authors seem shocked about, is that the Supreme Court was willing to take a case, West Virginia versus the EPA. That seems like a hypothetical. The Clean Power Plan does not exist, and Biden has not made a new rule yet. Well, the reason why that is shocking to many is because there is a constitutional law principle called controversy. Citing to Black's Law Dictionary, as well as my own remembering of constitutional law course, for the Supreme Court to hear a case under Article 3 of the U.S. Constitution, as interpreted by the courts, and that's called case law, there must be a dispute or controversy that is definite and concrete, not hypothetical. The court isn't supposed to act as some type of grand advisor. So since the Clean Power Plan is not in effect and no new rule has been written, many constitutional law scholars would argue there is no controversy, and this is not a case that should have been brought before the Supreme Court at present. So quoting Sheldon Whitehouse, Democrat of Rhode Island, a strong climate activist, by taking this case, the Supreme Court threw away tradition. Well, standing on tradition is a bedrock principle of constitutional law. It's called stare decisis. It's Latin for to stand by that which was decided. That way the law is not arbitrary. So what does this case mean for things going forward? Part of the court's reading of the Clean Air Act, or their findings, if you want to call it that, is that somehow Congress granted authority for the EPA to engage in pollution control measures, like here maybe I'm imagining, the carbon capture and scrubbers on coal, things that for the most part don't really exist, but it does not authorize them to encourage a transition away from fossil fuels. Even though you could have just as easily read the Clean Air Act and read that subsequent Massachusetts versus EPA granting them authority to regulate greenhouse gases to grant that authority. The court also took the opportunity to introduce into the regulatory standards something called the Major Questions Doctrine. Now, this might at first sound reasonable to you on the surface, but we've got to look below the surface and think about what economic interests are being served. Under this doctrine, the court now holds that when regulatory agencies are engaging in something new or novel, and these actions might have, quote, vast economic and political significance, then the court should no longer just defer to the agencies, But now the agencies, it seems, need to go to get authorization from Congress, specific authorization for that. Well, the practicality of this, as the NRDC points out, is that introducing now this major questions doctrine is that anytime the EPA wants to introduce a new rule, some industry can now challenge this, saying there's a major economic impact, thus slowing down that change, and then hoping the EPA will then go to, or whatever agency will then go to Congress, but Congress is gridlocked. And I've shown you in other videos that there's millions of dollars in campaign contributions coming from the fossil fuel industry to Congress, and the lion's share of that goes towards Republicans. So just think about that fossil fuel industry and what economic interests are served by saying, yes, you can put scrubbers on smokestacks and that kind of thing, but you cannot require a transition away from fossil fuels. And anytime you want to do something new, there's going to be arguments made that it could be a major questions doctrine issue. What would be the underreported economic incentives of judges making a decision like this? Well, underreported, we can again look to a Mother Jones article citing that Amy Coney Barrett's dad was a longtime attorney for Shell Oil. Sheldon Whitehouse at his website, and I don't have time to go into this in depth in this video, but he points out that all these so-called conservative judges had backing of what's called the Federalist Society. And the Federalist Society, when he was still able to find who was donating, he found donations coming from what he calls wealthy mega donors, including those with fossil fuel ties like the Koch brothers. Well, now Whitehouse points out that the Federalist Society has received in the past decade, around $40 million in what are called dark money or undisclosed donors. But what do those donors expect, who we don't even know who they are, in return for these judges that the Federalist Society is promoting? And if this idea, looking at economic impact, still sounds reasonable, which on the surface it sounds reasonable, keep in mind too that there was an underreported study done by an author named, I believe his last name was Franta, and I'll provide you a link to that, showing fossil fuel sponsorship of economic studies. And those economic studies then used in turn and cited by people like President Trump to then justify the continued use of fossil fuels. And all these economic ties the media is very little interested in exposing. Well, hey, I hope you found this breakdown of the EPA versus West Virginia helpful. And if you did, please make sure you're subscribed to my channel, you're liking, you're commenting, you're clicking the notification bell so you know when I put up a new video, you're donating at Patreon. These shows take a lot of work to put together. And until next time, and as always, peace be with you.